to read their dissents.
According to the judges, it all started going wrong the time polls closed at 5 p.m. According to the bench, the IEBC failed to inform the public the source of results that were already streaming into their portal some minutes after voting closed, calling to question the integrity of the vote transmission process, which it held was just as important as the election result.
Elections are not only about numbers, as many, surprisingly, even prominent lawyers would like the country to believe. Even in numbers, we used to be taught in school to arrive at a mathematical solution. There is always a computational path.
It is our finding that the illegalities and the irregularities committed by the first respondent were of such a substantial nature that no court properly applying its mind to the evidence and the law as well as the administrative arrangements put in place by IEBC can in good conscience declare that they do not matter and that the will of the people was expressed nonetheless.
The court returned a harsh criticism of the IEBC for announcing results based on dubious result forms. They questioned why it took time to avail all the Forms 34A days after the results had been declared, and if the scanned forms had been sent simultaneously to the constituency and national tallying centres according to the law.
We were disturbed by the fact that after an investment of taxpayers' money running into billions of shillings for the printing of election materials, the court would be left to ask itself basic fundamental questions regarding the security of voter tabulation forms.
A report by the Supreme Court Registrar Esther Nyakiaki upon scrutiny of the result forms, as ordered by the court, also pointed out a number of issues of concern. Still, the answers provided by the IEBC lawyers in court were inadequate.
The submissions of Mr. Nyamodi on behalf of the first respondent made disturbing, if not startling, revelations. What was Mr. Nyamodi saying? Was counsel admitting that the second respondent indeed, as claimed by the petitioners, had declared the presidential results without having received all Forms 34A? Was he in the same vein also admitting that not all Forms 34A had been electronically transmitted to the National Tallying Center from the polling centers as required by law? Where did the language of statistics as opposed to results emerge from?
The Supreme Court called out the IEBC for failing to open their servers for scrutiny, saying it would have debunked some of the claims made against them by NASA that their systems had been interfered with. According to the judges, the non-compliance means NASA was right all along.
Our order of scrutiny was a golden opportunity for the IEBC to place before the court evidence to debunk the petitioners' said claims. If IEBC had nothing to hide, even before the order was made, it would itself readily have provided access to its ICT logs and servers to disprove the petitioners' claims.
The court also refused to accept the IEBC's explanation on failures in technology, particularly the deficiencies in scanning all the result forms due to poor network coverage.
IEBC's ICT officials must have known that there are some areas where network is weak or totally lacking and should have made provision for alternative transmission. It cannot have dawned on IEBC's ICT officials 2 days to the elections that it could not access network in some areas.
The IEBC could also not adequately explain why there were more votes cast in the presidential race than in the other seats. Overall, the court found that the Commission had failed the simple test of a simple, verifiable, accurate process and was unfaithful to the Constitution and electoral laws in their conduct of the election. The judges say they annulled the election since the Commission could not provide adequate proof to counter claims made against them.
Having fulfilled the requirement by law,
the chairman, on his part, was held responsible for failing to explain the missteps in the electoral process. So that is why the Supreme Court nixed the presidential election of the 8th of August in a ruling that was seen as a boost to the country's democratic credentials and cemented the independence of the judiciary. But not everyone sees it that way. There's been questions about the reasoning behind that judgment that is still a very rare one in the world. The judges, in conclusion, trying to answer some of these questions.
There is no denying the fact that the election of a successful candidate is not likely to be interfered with by the courts. The courts generally lean in favor of the returned candidate and place the onus of proof on the person challenging the end result of an electoral contest. That approach is more in the nature of a rule of practice than a rule of law, and should not be unduly stretched beyond a limit.
The Chief Justice reverting to his earlier rallying call on fidelity to the Constitution and fear of God as the closing principles to the judgment. Sheila Sendeyo, NTV.